Has this ever happened to you? All that air, that's called slack fill. And it could be grounds for you to sue the company that sold you that product. I'm Shaunik, rhymes with Sonic. I've been a plaintiff's litigator for almost 10 years. That means I represent people, usually against corporations or governments. I love the law, and I love using it to help people. I'm going to talk to you about the air that chip companies inject into their bags of chips, slack fill, why it exists, the laws surrounding it, and how consumers might actually be able to go after those companies in court. Slack fill is that empty space between the food in your packaging and the packaging itself. Slack fill can be super annoying because you feel like you're getting cheated because you're getting so much air when you should be getting that package full of whatever food you're buying. But at least according to the FDA, there are some legitimate reasons for slack fill. The slack fill could be a byproduct of whatever means they're using, whatever machinery they're using to create the packaging and package the product in the factory. So it isn't a situation where they're sort of trying to cheat you out of what you're supposed to be getting. The machines that are making the package and packaging the foods simply create that amount of space. The slack fill could be intentional, but it could be for a good reason, like for protection. You don't want to get a bag of chips, open it up, look inside, and see it's full of crumbs. So that padding, that cushion of air in the bag of chips is usually to protect the chips from getting smushed in storage and in shipping. Maybe the packaging serves some sort of other function, like it has a little pouch or a little pocket for sauce. And so it comes with a little amount of air there and a gap, but that's actually there to put something in and is related to the purpose of whatever you're getting. It could also be that there's some unavoidable settling. So usually in harder containers, things may settle to the bottom and create gaps that may not have existed at the time of packaging, but simply happened from storage for a long period of time. Or maybe there's a reason why the packaging just can't shrink any further. Like if you take a bag of popcorn, the popped kernels have so many edges and corners, there's a lot of air trapped between the kernels. There's only so much the bag can shrink. Even, putting aside the fact there needs to be a cushion of air to protect it from being crushed, there's only so much that bag can shrink because of all the air that's going to be collecting within the pockets between the kernels. And that might be a reason for slack fill as well. The place where companies run into issues with their slack fill is if it's non-functional. If that slack fill doesn't serve a legitimate purpose, it is non-functional slack fill, and it could be actionable. There have been plenty of cases around the country where plaintiffs have won on a theory of non-functional slack fill, that the product they bought contained way more space inside the packaging than was legitimately necessary for protecting or for function, and therefore they didn't get what they paid for. As you can probably tell, a lot of that turns on notice. What were consumers put on notice of by the packaging? What did they think they were paying for, and what did they actually get? That's why if the bag is transparent, like this bag, you can actually see how much of the product is inside. And so even if this slack fill here was non-functional, and I'm not saying it is, it's a lot of cushioning for the chips, but even if it were non-functional, because this bag is transparent, it's not opaque, a customer, a consumer, is put on notice of the amount of product in the bag. So they can't really come to court and say, hey, I was deprived of what I thought I was paying for, because the court will just say, well, you could see the whole thing the whole time. You were on notice of the amount of chips that was in the packaging. The same is true if the packaging has a label on it that very clearly states that you are going to get X number or X weight of product inside. Courts have dismissed slack fill cases where the packaging very clearly says 10 breadsticks or 6 ounces. And so if the weight or the number is accurate, then it doesn't really matter how much slack fill there is, because the consumer is on notice of the amount of food they're getting, regardless of how big the packaging is. Say you've got a legitimate slack fill case. You've got a package of food, that package is full of air, it doesn't serve any legitimate purpose, and you have no idea how much you're actually getting because it doesn't disclose it clearly on the front of the packaging. How do you actually pursue that claim in court? This is where we get into the kind of complicated legal stuff, the fun stuff. And I'm going to talk about two things. I'm going to talk about private rights of action and preemption. The FDA rules that govern slack fill, what is and isn't functional, non-functional slack fill, what the requirements are, those regulations don't have a private right of action. What that means is an individual can't go and sue under these FDA regulations. There is no private right to bring a civil action in court based on a violation of these regulations. Now, there are a lot of laws that don't have private rights of action. These are laws that are, a lot of times regulations, rules that are enforced administratively, either through the executive branch of a state or of the federal government, and others are there for criminal prosecution, for enforcement by the government in other means. There are plenty of laws that don't allow an individual to go and bring a lawsuit in court. That doesn't mean that other laws don't exist that allow people to go to court to enforce violations of those laws that don't have private rights of action. Here's what I mean by that. Every state has its own set of consumer protection laws. California, for example, has a bunch. Unfair competition law, false advertising law, the Consumer Legal Remedies Act, there's common law fraud. There are a bunch of ways in which consumers can sue companies for violations of consumer rights, for fraudulent, misleading acts, misrepresentation, false advertising. If a state has a law that says a company is not allowed to sell to a consumer a product that is in a misleading package, then a consumer who buys a product with non-functional slack fill can turn around and sue the company under that state's unfair competition law, saying this was misleading packaging. Why was it misleading? It was misleading because it had non-functional slack fill, because the packaging made it appear as if the contents were more or larger than they were in reality, that the consumer would have paid less had they known they were getting such a smaller amount than they were led to believe. The key is reasonably led to believe. A consumer cannot have an unreasonable expectation. And that's why opaque versus transparent packaging is so important. Because if a consumer were to look at a transparent package of chips and argue that there was non-functional slack fill and therefore it was misleading packaging, well, the court would say that isn't a reasonable expectation to have, that there would be more chips in there, because you could literally see the chips inside the bag. If a consumer can sue under state laws for misleading packaging, then why does it matter that the FDA has these regulations around slack fill? Couple of reasons. The first is that some state consumer protection laws allow consumers to pursue claims for violations of laws. So they allow a consumer to basically bootstrap a violation of another law into the consumer protection law of that state. Under California's unfair competition law, you can sue under the theory that the defendant violated some other law and therefore engaged in unlawful, unfair competition just by violating another law that exists. Because this company profited from violating federal regulations, California provides an avenue for individuals to seek recovery. But on the other hand, the presence of these federal regulations provides a potential defense for defendants, and that is through something called preemption. See, the FDA rules have specifically enumerated defenses. It's sort of a safe harbor provision. They are a handful of legitimate reasons enumerated in the federal law that a company may add slack fill. So if a company adds slack fill for any of these reasons, the law basically says, well, that's functional. And as we know, the law only penalizes non-functional slack fill. And because it's a federal rule, it supersedes any state law rule that would be contrary to its purpose or effect. That's preemption. That means if you try to sue a company under a state consumer protection law because they did not have the amount of product in that it seemed that they should have from the packaging, but the reason for it was one of the safe harbor reasons enumerated in the FDA rules, then the FDA rules would preempt that state law claim. They would supersede it and prevent you from bringing the action. Basically, federal law has spoken on this particular area and therefore has preempted all the contrary laws in that particular area. Now, these cases began to get super popular a little over 10 years ago. And in fact, so many of them, a disproportionate number of them, were being filed here in the Northern District of California. That's where I live. It's where I practice. The federal courts that are in San Francisco. And because of the disproportionate number of slack fill type cases that were being filed in ND-Cal, in the Northern District of California, that federal district court was being referred to colloquially by lawyers as the food court. That's no longer the case. Now, I think that honor goes to the Southern District of New York or one of the federal courts in New York. That's where more of this type of litigation is being filed. But for a time, it was here. When these cases are filed, they're most often filed as class actions. Why? Because the individual recovery for a case like this is relatively low. Even if the statutes that you're suing under allow the recovery of some sort of penalties, they're relatively low for an individual person and usually not enough to justify hiring a lawyer, let alone pursuing a fairly complex lawsuit in federal court. For example, one of the means of recovery in a false labeling, misleading packaging type case is called restitution. Restitution just means getting the amount that you paid back. But the kicker is you very rarely get full restitution. You get what's called price premium restitution. That is to say, you get the value of whatever the difference is between what you paid for and what you thought you were paying for. So if you thought you were buying a bag that was filled with 100 hard candies and you paid $10 for it, but in reality it only had 50 hard candies in it, you might say that I paid double the amount that I should have. Based on the packaging, I believed I was getting 100 hard candies. And I paid that money that I paid $10 based on that assumption. I intended on paying 10 cents a candy. I actually paid 20 cents a candy because there were half as many candies in the bag as I reasonably expected. Therefore, give me my dime back. Now, if you were to go to court and say, give me my 20 cents back per candy, give me the entire amount that I paid back, the court would say, did you eat the candy? And you'd say, yeah, I did. And the court would say, well, you have received some benefit, so you can't get all your money back. You can only get the amount of money back minus the benefit you received. All that to illustrate that price premium restitution can turn out to be a really small amount for the one person who is suing if they're suing individually. But as a class action, then they're suing on behalf of 50,000 consumers, and that amount times 50,000 ends up being quite a significant amount. Of course, none of this may matter if you wait too long before pursuing a claim, because there are things called statutes of limitations which can bar your claim after a certain period of time. So the UCL, the unfair competition law I talked about in California, that has a statute of limitations of 4 years. That means 4 years from the date of harm is when you have to file your lawsuit. And after that point, you could be forever barred from filing it. If you want to learn more about that, check out this video I did on statutes of limitations. Otherwise, thanks for sticking around, and I'll see you next time.